Being no hands raised, we'll proceed through the rest of the public session agenda. And our director will obtain the witnesses who want to talk to us about item number 7 from the League of Oregon Cities, who've been waiting for a while to appear before us. Will go on hold for a second. They're here in person.
One was in person, one was joining online. So we're trying to get
Is
the individual that was joining.
that Mr. Winkles online?
No, Mr. Winkles was in person and Jamie Pierce was
Is online? Okay, thank you. We'll wait to have Mr. Winkles arrive in the room as well as Ms. Pierce arrive online.
Getting Jamie in the room as well.
In the virtual room.
Right.
Let me know when we're ready to proceed. Welcome, Mr. Winkles. Please feel free to sit.
Thank you.
We're still waiting on Jamie. There in the room.
Ms. Pierce, can you hear me? You're on mute right now, it looks like. If you're on the phone, hit *6. If you're on Teams, do whatever it is to unmute yourself.
Can you hear me now?
We can hear you, Ms. Pierce. State your name just so I can hear you again speak.
My name is Jamie Pierce from the
Thank
League
you,
of
Jane.
Oregon
We
Cities.
can hear you. We can hear you. Mr. Winkles is in the room. This is the time set aside, colleagues, for consideration of an advisory opinion drafted by our staff. 2 individuals from the League of Oregon Cities have asked for the chance to appear before us today. We'll hear from them in a moment. First of all, Executive, please summarize this advisory opinion for our review.
Thank you, Chair. So item 7 on your agenda is a commission advisory opinion to the League of Oregon Cities, and they requested this opinion following informal advice that was given, a letter of advice that was given to the mayor of Beaverton. And both the original letter of advice and this advisory opinion address the question of, under the ethics law, how is the provision of food and beverages to a public official from their own public body treated? Is it treated as part of the official's official compensation package under ORS 244.040 sub 1 and sub 2A, or is it treated as a gift? And in both the informal letter of advice and this opinion, after going through the analysis of 244.040 1 and 2A, and then going through the analysis of 244.040 subsection 2G, and the associated analysis of the gift clause and the gift exception provisions, the opinion is that the provision, the direct payment by a public body for the expenses of a public official, providing a meal or providing incidental food and beverage, falls under the definition of official compensation and would fall and be considered under ORS 244.040, not as a gift from their public body. The gift the prohibited use of office exception provides that the payment of direct expenses of a public official are part of their official compensation package, as the specific language in front of me a minute ago, are part of official compensation package includes the direct payment of a public official's expenses by the public body in accordance with the public body's policies. And how the commission has treated this in the past, at least in the 8 years I've been here, and in prior advice from former director, is that when you get something from your public body, we look at it under the use of office provision. When you get something from anyone else or any other entity, we look at it as a gift. So that was our advice, and that continues to be our advice. We do not specify what the policy has to say. And I would specify well, because hopefully this was going to be a slightly shorter meeting than usual. You are all well aware that in prior to meetings, you ordered lunch for the commission, for the staff who are working, and so forth. And the reason we are able to provide lunch to the staff during our meetings is that DAS has a policy saying staff may accept the provision of meals from their agency if in non-travel status. Again, simply get a policy in place, and it's permitted under 040 sub 2A. That is what our opinion says.
Executive, before we proceed to hear from two individuals who have asked for their privilege, and we will grant it easily to appear before us, any comments from colleagues to our executive based on her report and your reading of the draft advisory opinion? Hearing and seeing none, two individuals have asked to appear before us. One is Jamie Pierce, who is online, who is the General Counsel for League of Oregon Cities. The other is Scott Winkles, whom I have known for some years as a League of Oregon Cities representative. You may choose to proceed in any order that suits your purposes. And when you proceed to talk to us, either one of you just identify yourself for the record. Please proceed.
For the record, Chair Fiscum, my name is Scott Winkles, and I have been the League's lobbyist on ethics and other issues for the last 18 years. I was our lead lobbyist on the oath in 2007 for Senate Bill 10 and the re-reform of Senate Bill 10 in the 09 session. It became Senate Bill 30. Many of the things that you interpret now are in statute because of the League's efforts for years. I'm not an attorney, but I have worked on these issues for some time. With me today is Jamie Pierce. She is the League of Oregon Cities General Counsel. I would also call your attention to an email sent by a Chad Jacobs. I don't know if that was entered into the record or in your packet. Chad is the managing partner of Barry Elsner, and he is also online. I don't know if your rules allow comment from him as well. I think
Just for the record, Mr. Winkles, we did receive the communication from Mr. Jacobs.
We received the communication, but it was like 15 minutes before the meeting started,
Okay.
so certainly would include it as part of the record of the opinion, and it's up to
And
the
Mr.
chair.
Jacobs, if you're online, please stay online and listen to this discussion. So, Mr. Winkles, please proceed.
I will let our attorney, Ms. Pierce, to go into the legal arguments on this case. I will say that we'll point out that the 244040 requires that the public official use their office. And from our perspective, the examples that we provided that we're asking advice for, subsequent to the advice to Mayor Beatty, do not involve an official using their office. And I think the comment that was made in the earlier case by excuse me, your executive director, was, did you create an opportunity for yourself? And I think that was said in one of the preview cases this morning. The examples that we've provided in the incident in Mayor Beatty involved an official whose part of their job function was to attend an event. They did not plan the event. They did not order the food. They did not pick the menu. My understanding of the Beaverton team building, the menu was Costco hot dogs. They did not select those. They were simply asked to be at a team building event in which food was incidental. They did not use their office. I will also point out that the advice given seems to be a significant departure to how it's mentioned and trained for in the manual. The examples offered in the manual include some things that we would all agree are unethical and inappropriate. So using the firefighter, using the pressure washer, the billing clerk not charging their a family member, which is unethical. It's probably also theft. There are several examples. I would have gone with the public works crew that used the crane on the truck to hang their deer after hunting season. But you write your own documents. All of those examples involve the official doing things, using their office. They had to make plans. There was intentionality. Our examples involve people who have simply been where their agency required them to be, and there's food. That in there lies the difference. And so with those initial comments, I would happily turn it over to Jamie for additional conversation.
Ms. Pierce, please proceed. Identify yourself for the record. Thank you for being online today.
Thank you, Chair Fiscom and Commissioners. Again, my name is Jamie Pierce. I'm the League of Oregon City's General Counsel and the one who officially submitted the request for opinion. And thank you for the opportunity today to provide comments on something that normally does not receive so many comments. Again, the draft advice relates to, the acceptance of food and beverage that's incidental to someone's position and whatnot. And we believe it erred in its conclusions. Specifically, the draft advice highlights 3 applicable statutes, and that's the 040, known as the prohibited use of office provision, 025, the gifting limits and provisions, and then specifically 020 sub 7, the definition of the term gift. The same statutes provide for a number of exceptions to the prohibited use of office, and 040 relevant include, as we know, the official compensation package, a validly accepted gift, or receipt of any item that's specifically excluded from the definition of the term gift. There are 15 items that are excluded from the definition of gift, and noteworthy, 4 of those exclusions involve food and beverages. As this commission is well aware, the intent of the ethics laws is to prohibit public officials from using their office for personal gain in forms of profits, gifts, favors, or promises of future employment. First, the draft states on page 6 that gift laws and relevant gift exceptions are not applicable to situations where the public official accepts food and beverages from their own public body. LOC's concern with this conclusion is that there's no foundation or citation of, 1, where this conclusion exists in either statute or administrative rule, any citation to the legislative intent for that conclusion to be included, or we were not aware of any sort of prior OGEC interpretation of that precedent. So again, we have concerns about the finding in where food and beverage or any receipt is always only in the form of compensation. Second, the draft advice states on the same page that when a public body provides food and beverage to an employee or elected official, it's doing so in exchange for valuable consideration of public service that the employee or elected official provides to the public itself, which value far exceeds the value of food and beverage provided. Again, LOC's concern with that conclusion is that the assumption is incorrect and not actually true in all situations. For example, food and beverage could truly be incidental to a baby shower, retirement celebration, and not provided in exchange for, quote, valuable consideration. The draft opinion conclusion assumes that a public body could never gift food or beverage to one of its public officials, and that all food and beverage, no matter the purpose, is solely in consideration for that official's service and not the celebration of milestones or achievements or anything else. And while the exception for official compensation is certainly a potential exception to 040, LOC does not find anywhere in the ethics laws that this exception excludes other potential applications, such as the one for a validly accepted gift, or one that's excluded from the definitions of a gift also apply. And then third, again, on the same paragraph, the draft opinion states, additionally, when food and beverage is provided to a public body, only to its public officials, the food and beverage is not available to non-public officials at all and not on the same terms. Therefore, the food and beverage provided to the public body to its own public officials is not a gift that should be analyzed under the gift laws. This assumption, again, that compensation is the only possible categorization is contradictory to the definition of gift itself. As stated above, a gift is defined under 244020 sub 7A of, quote, something of economic value given to a public official, without valuable consideration of equivalent value that is not extended to others who are not public officials on the same terms and conditions, or for valuable consideration less than that required from others who are not public officials. So the LOC believes that this conclusion should be reconsidered and is incorrect as presented in the draft advice. And then finally, specifically to the prohibited use of office, as Mr. Winkle stated, it requires that the public official in question is, quote, using their position for financial gain or the avoidance of financial detriment. LOC's position is that the scenarios presented, public officials are not using their positions for financial gain. In addition, using the Administrative Rule 199-005-0005 guidance for the valuation of financial gain determination, the real value being, quote, gained in such group settings is nominal at best. Furthermore, in the same administrative rule, it contemplates that there could be even charitable contributions. Looking to the legislative intent, it's apparent that the acceptance of these types of food and beverage offerings is inconsequential and de minimis. Moreover, as the Commission is well aware, the intent behind the ethics laws is to prevent government corruption and undue influence. In examples provided, there's no corruption or influence being presented. Rather, the focus is on gatherings that are the opposite, team building to effectuate effective decision-making. The interpretations provided in the draft do not align with the legislative intent. Under the proposed advice, a city employee could not accept a cookie and coffee at a city-sponsored celebration because their city does not include a receipt within the formally adopted compensation package. However, the same city employee could accept such food and beverage if it was paid for by a third-party contractor wishing to secure business with the city. Under the conclusions provided in the draft advice, the prohibited conduct, which is the receipt of the coffee or cookies from its city, which is arguably less corrupt and less influential than the permissible conduct, which is accepting food and beverage or anything else under the gift provisions from a third-party contractor who wishes to secure business from the city. And finally, based on the interpretation, public officials who have consumed even a mere glass or bottle of water provided by their public body during a meeting or at any time have violated state ethics laws unless the consumption of water was included in a formally adopted compensation policy. So I urge this commission to reconsider the draft advice and reconsider the basis of relevant statutes and administrative rules and consider the scope and reasonableness of their practical application. Thank you very much for the opportunity.
Thank you, Ms. Pierce. Mr. Winkles, are you willing to engage in a discussion or answer questions?
Of course.
Thank you very much. Ms. Pierce, I presume you're, okay, colleagues, any reaction to this? I'll turn in a moment to executive and other staff, but commissioners, any comments from Ms. Pierce or Mr. Winkles?
Commissioner Mason has his hand up.
Commissioner Mason, please proceed. Thank you.
Yeah, just a humorous point. I mean, somebody from the commission might want to hire her because she was Ms. Pierce did a very thorough job with her presentation there. No, I'm interested in hearing from our attorney his perspective. Thank you.
Thank you, Commissioner. Okay, executive or others, please, any comments you make in response to those who testified, please proceed.
So the question is posed is whether we analyze it under 040 versus 025, whether we analyze it as use of office or as gift. As we say in the opinion, we're not making a determination that there would be a violation or a use of office. That would be dependent on each individual factual circumstances presented if a case were presented to us. What we're saying is that how the commission will analyze the situation of the public body providing food and beverages is that we will analyze it under 040, 1 and then 2A, not under 025. I just wanted to make that clarification. And
any other comments from director or others relative to the commentary from our witnesses today? Council, you have any comments? And you don't have to.
I'm not going to comment because that's not my role.
Provide your advice to me.
If you have questions, I can certainly answer questions.
I understand.
Related to the draft advice.
Thank you very much. I appreciate it.
Yep.
I guess my my question, which is not on the substance of what's been stated to us relative to Mrs. Pierce's comments on the 6th page, for example, in the several citations she made. Does anything that was said to us today in the last moments yield give rise to a possible decision to hold off on this opinion? And so we have time to reflect on what's been suggested to us today, or would you advocate we proceed in any event? You understand what I'm saying? Possibility exists to me in light of what's been said, not to say it's right or wrong or anything else, but we hear this commentary from quote constituents, unquote, those who are affected by what we do, and reflect on this opinion to see if it's really what we want to proceed to a commission vote on later on in a meeting later, perchance.
So, the commission cannot consider this opinion at a future meeting.
Say that again?
The commission cannot consider.
Cannot?
No, we do not have any additional time that we can consider this. It's already, it got extended once. We're out of time next week to consider. You can decline to issue the opinion, or you can issue the.
How is time extended?
The commission voted to
No, but
extend.
is it our vote on the time, or is it a collaborative venture with
No,
with others?
it is the commission has one extension allowed to it in statute.
So we've made that
Commission-
extension, so we
Correct.
can't extend again. I'm seeing hands
Correct.
nod. Thank you. I'm learning something every day I come here.
If your question is what has been said, does it change how I would interpret the statute or how we would apply the statute? No, I understand their reasoning, but if the reasoning is one, the administrative rule clearly says the direct payment of the public officials' expenses is part of their official compensation package. Adopt a policy, it gets accepted out. Two, as I explained in response to Scott's comments, we're not saying that any particular official would have used their position. That's a determination that would have to be made on a case-by-case basis. What we're saying is, when should any of those cases come before us, we would examine it under 040. And while we do not get a lot of gift cases, we do get a lot of cases, and we'll continue to get cases where public officials are accepting items, whether it's food, whether it's equipment or anything else from their public body. And the commission has always addressed those under 040.
Let me ask, waiting for my colleagues, did Mr. Mason, Mr. Mason, hang on one second, just another question to get at my issue. Is anything that was said about particularly with regard to elements of page 6, prompt you or anybody else to consider the possible need or advice to rewrite that paragraph in a different way? It strikes me that one of the witnesses suggested that this could result in very unusual, silly situations if these words were taken at face value. Is there any need you would cite to rewrite that in light of what's been said today? And if the answer is no, I'm not arguing with you. I'm just asking.
No, I don't think it does. I don't think we would need to rewrite it, because in those silly situations, should they come before us, we would look and see, one, is there a policy existing or something in their employment agreement saying the employees can get this? And if so, it's part of their official compensation package and there would be no violation. And in the absence of that, then we look at 040 sub 1, and that would require us to look at, did the employee use or attempt to use their position to obtain something of value?
Thank you. Mr. Mason, please.
Thank you, Chair. I was just trying to clarify with the executive director if she stood by her decision with this opinion, or, and the attorney does as well. And I think, if so, which sounds like she just answered, then it should probably be adopted. Thank you.
Hey, Commissioner, any other comments from colleagues? Since I've dominated, I will stop dominating and yield the floor to any of my colleagues who choose to ask a question, make a comment on the matter before us, on the matter before us. Hearing and seeing none. Vice Chair, any thoughts about this issue from your vantage point? If not, so be it.
No, I mean, I'm looking at this and I guess I don't see a large burden for public entities to adopt a compensation policy. It seems like a simple step that would cure the problem. So I don't have a problem with this advisory opinion. And I'm inclined to adopt it.
Thank you, Vice Chair. Appreciate putting you on the spot, but thank you for your comment. That tends to be where I am as well, what it's worth. Any other comments from colleagues? One last time for Mr. Winkles and Ms. Pierce, anything to respond quickly? And we're on a tight time frame, so very quick.
I would have a comment really quick if there's
Ms.
time.
Pierce, please proceed quickly.
I appreciate that it seems very simple for cities, we represent cities specifically, to adopt a simple compensation policy. I would really urge this commission to consider that, yes, the commission itself, as the example that the executive director provided, has a whole other state agency who can adopt policies on its behalf. Cities across the state, as large as 2 people, do not have that same luxury. In addition, if they were to try to pass a compensation policy, it might even include a charter amendment, which this commission has already stated, if there is a financial element there, they could be faced with a conflict of interest. So I just would really ask that this commission consider that in some situations, it may be incredibly simple to have a compensation policy passed or amended, but for the majority of cities in the state of Oregon, that is a very large, if not practically impossible task. Thank you.
Thank you, Ms. Pierce. Mr. Winkles, any quick?
I would like to respond directly to the comment that it's not a significant burden. Adding anything to the compensation package does 3 things. Compensation packages are mandatory subjects of bargaining. They are subject to pay equity, and they create tax implications. I will also point out that you have documents from 2 attorneys whose advice also confers a certain level of protection against an ethics complaint. An elected official acting on advice of their counsel, or a public official acting on advice of their counsel, may only receive a letter of education. That is in the statute. You have heard from 2 very experienced attorneys who give advice on ethics issues regularly that would confer that advice. This creates a very significant conflict between what our attorneys view as the status of the law. They are required to provide their best advice to us and the commission.
Thanks, sir. Appreciate it. Thank you. Colleagues, now's the time to decide on this matter before us, which is the draft advisory opinion. Any further comments, suggestions on how to proceed, or a motion? Vice Chair, are you prepared to make a motion? If not, I'll find somebody else who is.
Well, I guess I just have one more question for executive director, because I don't want to, make light of something that may be difficult. We have had people come before us before, with conflict of interest violations for voting on their own compensation. How would this affect the ability of, I guess, certain entities to be able to change their own compensation packages?
Okay, so So you're in a city and you are adopting a policy that would allow city employees and officials to accept non-food while in non-tribal status. And in your compensation package, you would announce a conflict of interest. I think it would arguably be a potential conflict of interest in that you do not know whether the city will actually provide you with any food. It's providing the opportunity for the city staff and officials to receive food in these situations.
Colleagues, question, Vice Chair, follow-up?
No, that's helpful. Thank you. Okay, I'm prepared to make a motion, and I don't think I have one on my list, so I will move that the commission approve agenda item 7, the advisory opinion for the League of Oregon Cities.
Comments on the motion, colleagues, before the vote is taken?
Mr. Chair.
Please, Commissioner Thompson.
Thank you, Mr. Chair. Well, it sounds like our executive director and our council are comfortable with it, so I have to rely on their advice. But if there's some discrepancy in state law being vague, there's nothing we can do about that. But
Other than change the law later.
I would encourage folks to lobby the legislature.
Yeah.
Get that changed. I mean, I remember Mr. Winkles well from the Senate Bill 7 and Senate Bill 30 days. So, like I said, I just have a hard time going against our executive director and our council when this is their opinion. Off we go.
Thank you for your
Just to
comment.
correct, it's not my opinion, not DOJ's opinion. We signed off on the opinion as it's presented to the commission, just to clarify that.
Thank you for the clarification.
What he said.
What he said. Thank you, council. I appreciate the distinction. So appreciate that clarification for the record. Colleagues, any other discussion on this matter before us? The administrator will call the roll on the proposal to adopt the advisory opinion before us, item 7 on the May 9th, 2025 agenda. Please call the roll.
Commissioner Thompson.
Aye.
Commissioner Mettler.
Aye.
Commissioner Burke.
Aye.
Commissioner Payne.
Aye.
Commissioner McCauley.
Aye.
Commissioner Mason.
Aye.
Commissioner Resendez Gutierrez. Sorry, he's not here. Commissioner Jancy.
Aye.
Chair Fiscom.
Aye.
Motion passed 8-0.
Thank you, colleagues, and thank you to those who appeared before us in the last moment. We appreciate your patience with our long agenda today as we head toward the conclusion. We have one more item on our agenda, I think, unless we want a trainer's report.
No trainer's
No
report.
trainer's report. We will now hear briefly the executive director's report on your agenda today. Please proceed.
Thank you, Chair. So first, let's talk about budget. The current surplus is before you. The budget bill, Chair Fiscom attended, we had a work session between the Joint Ways and Means General Government Subcommittee on Tuesday, and they passed it through.
Approved it lock, stock, and barrel.
Yes. And then the work session before the full Joint Ways and Means Committee was this morning, and Becky can report on what happened.
It went through. There was a couple of questions about SEIs in school districts, CMS and EFS updates. There was a question about our DOJ bill. Sorry, Sean.
That was Dan. Right.
That is online.
Well done.
Other than that, it went through.
Any no votes?
The
remember?
usual Bontham, and Mark Owens
Bonham voted,
Yeah.
Senator Bonham voted no.
and Owens.
Mr. Owens, yeah, thank you very much.
When you say the usual, are they voting no on most budget bills? Or they just don't like us?
Well, Rep Bottom took over from, well.
Okay, never mind.
We appeared before Senator Bonham a couple of years ago, and he was very inquisitive and positive about ethics issues before him. And things have changed a little bit, but in the whole scope of things, it doesn't matter. So
Gotcha, fair enough.
Long day.
please proceed.
Legislative session, we have, from our original 5, we have 2 bills that are proceeding through. They had public hearings, House and passed. They had the Rules Committee hearing and passed, and there are work sessions. They're no longer tentatively. They are scheduled for next, I believe that's Wednesday.
Senate rules or House?
In Senate rules.
Senate rule. Yeah, thank you.
They already passed us.
Right.
We are obviously continuing to monitor. I had Becky forward me the CI and lobby cases. So obviously the deadline for filing SEIs was April 15th, but as you know, there is a built-in grace period for SEI filers, so penalties do not begin to accrue until May 6th, several days ago. Our staff worked very hard to try to contact everyone who had not filed in time and get them filed. And we are down to only 70 people who have not yet filed their SEIs. And then lobbyists and clients for the first quarter, we're down to 11 lobbyists and 12 clients. Other than that, we're good.
Thank you. Any final comments for the good of the order other than thank you for lunch? That was my comment.
It's starting to sound like me down there.
I apologize for that. Colleagues, any comments for the good of the order? Our next meeting is,
June 13th.
we're now on a monthly schedule, roughly speaking. Thank you. Thank you for your patience today with an agenda that ran a little long for a variety of reasons. It had also included some accomplishments, so thank you for all your participation and help to get it done. Commissioner Jancy, welcome to your new job. Good to see you again. As always, Vice Chair, thank you. Commissioner Mason, hang in there. Others, we're now stand adjourned.
Thank
Thank you all.
all.
Thank you.
Thank you.
Come to